350, and it is only about 3 minutes from the time. Good morning, all the participants, and this is Anil Goel from AAA Group. Today we have the subject of valuations and its impact on insolvency and valuation standards. The speakers today would be Ankit Goel, who is a chartered accountant and a registered valuer. He's also a founder of AAA Valuation Professionals LLP, which is the registered valuer entity as recognized by IBBI. We also have with us Mr. Rakesh Mehta, who is a registered valuer, and he is the CEO of AAA Valuation Professionals LLP. He's an engineer by qualification and a registered valuer, and he's got an immense experience in mechanical engineering and plant and machineries. We also have Mr. Anil Sharma, who is an engineer from IIT Delhi. He is also an insolvency professional and a valuer. He is a partner in AAA Insolvency Professionals LLP and also AAA Valuation Professionals LLP. We have Mr. Nitin Jain, and he's an investment banker, and he is has a good experience of financial valuations of securities and financial assets. He's also an insolvency professional handling large cases, and he's also a valuer. So he's also partner in both our organizations like AAA Insolvency Professionals and AAA Valuation Professionals. So with this, we would like to open today's webinar, and I would say that the importance of valuation is very large. And see, for the last 3 years, I used to say that this insolvency professional is the best profession. Now, since the introduction of draft valuers bill, I think the profession of valuers also is going to take a very, very positive turn. And most of the valuers in the country, they would see their career again blooming, and their regulations and their value would actually increase in the market. See, the subject of valuation and its impact on various valuations, maybe it is for insolvency and bankruptcy code, or it is for SARFAESI, or it is for transactions of mergers and acquisitions. It is very, very important. And we would not like to cut and force close the webinar today. In case we would see that we are able to complete what we want to say, then we will complete it today. Otherwise, we'll make it as part 1, and part 2 will also start next Sunday on the same time. So that also we should be very well prepared, that there is a possibility that in case there will be more questions from the participants, we would like to handle questions as it comes. So the format would be that we are every 30 minutes, we would be taking questions every 30 minutes, and we would only like to restrict to that subject which is presently being spoken, and we would like to take questions on that subject. And the questions would be taken by any of the panelists, and the answers also can be given by anyone who feels appropriate. So with this, I launch this webinar, and I hand it over to CA Ankit Goel.
Good morning, everyone, and it's a pleasure to see you all in the morning today and on Sunday morning, ready to participate in this webinar. We are all, as participants, looking forward to a learning experience, and I think we will all learn from today's discussion on how the valuation under IBC is important and how it should be taken. We will also go in detail into the technical standards, into IVS, into the IBC law, into the company's registered valuer and valuation rules, and what are the requirements from the valuers, what are the requirements on part of valuers, how the valuation reports affect the whole insolvency process, how they affect the resolution professionals. So we will be covering all that. I will now move on to our basic topics of agenda. This is almost the same that we have circulated to everyone as the contents of today's webinar. And we will first be talking about the importance of valuation in CIRP and the liquidation process in IBC. We will be talking about fair value, liquidation value, realizable value, and how these different premises of value have been dealt in international valuation standards. Then we will be talking about the value appointment process and the valuation process. This is again a very important point because this process defines the whole valuation process, and it is, I think, many of us will be interested in understanding various IBBI related orders and NCLT judgments with respect to the value appointment process. Then we will be looking into the computation of enterprise valuation and how computation of enterprise value will be is important for computing the fair value, liquidation value, and realizable value. Information in documents required by valuers for accurate information. This is again very important because here we will be talking about what is the importance of each and every document or each and every information that we normally ask for when we are doing valuations, and how that affects the valuation process. How, if we take any assumptions with respect to those informations or documents which are not available, how they affect the valuation and the quality of valuation. We will be subsequently talking about limitations for valuers in conducting IBC valuation assignments and how they can be addressed, how there are alternative ways to those limitations in coming out with a valuation report or with a valuation number that addresses the requirement of the process. Then valuation report under IBC and how what are the requirements to comply with the standards rules. And again, we would like to talk about for the IRP, how the verification of valuation report is important and what expectations should they keep from the valuation report. Because one of the interesting things is that the RP is the responsible person to get the valuation done, to get the correct valuation done. And therefore, a primary understanding of the valuation process is adopted by registered valuers is important for the RP himself to verify the valuation reports. So I will now seek. So this is very, very important as to why IBC, why accurate valuations are important in IBC, and maybe I can ask Mr. Goel to take this forward and maybe discuss a little about in how, in his experience, how IBC valuations have played a key role in the process of IBC.
Certainly, Ankit, this is a very, very important issue as this moment under insolvency also, under SURFACE also, and even under other transactions. If the valuation is not correct exactly as close as possible to the market value, then the transaction would not happen. And if the transaction would not happen, it will disturb CIRP, it will disturb liquidation, or even it will disturb the transaction for which the valuation is being done. We can take certain examples like in the past that we have suffered because of incorrect valuations. I would start with my first case as an insolvency professional. That was LML Limited Kanpur, and we had 70 acres of land in that case, and that was also in the industrial area of Kanpur. While it was being valued, it was valued as per the local rates. However, when the COs, when they see there were 5 resolution applicants and they competed fairly between each other, and it was an open bidding process. And in the open bidding, the 180 crore had actually gone up to 223 crore, but somehow it was still short of 100 crore short by the valuation. So the COC had no option at that time to reject the resolution plan. However, in case we see we analyze the resolution plan, the discount factor which was required for 70 acres of land in an industrial area, that was not applied. And in case we see as a backdrop, so still there is no customer for that particular land at that particular value. So considering these kind of examples for various situations like a spinning mill, recently I got a spinning mill valued, And we have instances in the market like 32,000 spindles running factories being sold at a price, or 40,000 spindles are being sold at a price. However, it was valued basis on the land value and the building value and the plant and machinery value, uh, and that totaled up a huge amount, uh, because the current market value of the building was calculated as the kind of construction. And see, like in case we see the perspective, the location of that particular factory is away from uh, population area, and there is no particular use of that particular land and building. It only can be used for the spinning mill, and the spinning mill profitability has gone down to an extent that it has to be valued based on the uh, earning capacity. So that is also disturbing. So we are not able to find a buyer at that value. Then the stakeholders consultation committee is also not ready to reduce the price so frequently as it is required in this case. So there are multiple cases, Ankit. I will keep sharing in between. I think because this is
I will.
a very, very large issue, so I would not like to consume more time of your contents. These contents are very, very important. So I will just, uh, in between, I will also share certain other experiences.
Great. So basically, the idea is, as Mr. Goel shared, that valuation report guides the actions of the IP, COC, NCLT, and there is no dispute over this fact. In fact, we will mention some NCLT judgments where the NCLT has taken cognizance of the valuation report or the numbers in the valuation report and then
So
proceeded with the action.
there is a feedback that the voice is lower. So we actually have to be a little closer to our mics so that everyone is able to hear us properly. This is kind of feedback that I'm getting on the chat box.
Is it better now? I think this should improve now.
Much better now.
Yeah.
Yeah.
So what I was saying was that the valuation report guides the actions of the IP, COC, and NCLT, and there are various NCLT judgments where the NCLT has taken a company to liquidation, or even in some cases, completely dissolved the company based on the valuation report, where the valuation was minuscule. The NCLT has processed it. So imagine a situation where the NCLT proceeds with the liquidation or dissolution of a company where the valuation is erroneous. That will be really, really harmful to the interest of the creditors. FE, LV, RV, they're frequently used by IBBI for statistical purposes. So whenever we see IBBI coming out with news items where they say that, yes, this was the liquidation value, and the resolutions so far have fetched us this many times of the liquidation value, the liquidation value is what they are relying on in publishing how the IBC process is successful or not successful in gauging the performance of IBC. In the Committee of Experts report which is the Committee of Experts report for the new draft valuer bill, there is a very, very interesting statement from the Committee of Experts. And in fact, Dr. Sahu has also mentioned this time and again, that a valuer typically competes with the market and endeavors to estimate a value which is more authentic than the price of an asset. So he's basically trying to say that the valuer is expected to discover a price which is better and more accurate than the market itself. So it is important for us to understand this expectation from the whole process from the valuer. Valuation report is, of course, a common cause for dispute. So we will also bring out some case laws where the financial creditors and other participants to the process, including the promoters of the CD, have taken a company or taken the RP to court to basically dispute on the basis of a dispute over the valuation report. And what have the courts decreed in those cases? Differences in facts between two valuation reports can be trouble for the RP. So basically, what we're trying to say here is that where two valuation reports have different bases, basically the facts itself or the assumptions itself are very different. There it becomes the RP's duty to merge those facts and come at a conclusion where you would have a equal assumptions or equal facts between both the reports. So if one valuer is missing totally some of the facts, then it is the duty of the RP to bring that out. positive effects of possible effects of undervaluation. So whenever there is an undervaluation, there can be an abnormal gain by the resolution applicant or the promoters of the company. There can be a loss of realizable value for financial and operational creditors. There can be possible loss of reputation for the valuer. And in case of overvaluation, there can be a chance of rejection of resolution plan, which could have been approved. There's a possibility of delay in liquidation process due to requirement to repeat the process. And there can be a lesser realization from the sale of assets due to loss of interest from market for the stressed asset. So in case you go to the market and say that this asset is worth 100 crores, and the market says and market assesses and says that this asset is not more than 50 crores, then the market loses interest. So if you would have a genuine valuation with you, which would have given the right valuation, you might have grabbed that market participant who was interested in buying the asset at its market price. But because you have said 100 and the market participant is saying 50, you might lose him forever. He might not come back even when you are ready to sell it at 50. These are
So
some...
Ankit, there are relevant questions subject to this, because already it is 30 minutes that we have started. So, so in fact, like this relevant question, not 30 minutes, but then there is a relevant question. One question which has been asked by Mr. Vinod Joshi, and that is a question like whether the valuation reports can be given to resolution applicant and the bank auditors. My answer is no. The resolution applicant can take the valuation report only after the resolution plan is approved by the committee of creditors, because then he will have to just see what exact asset is a part of the information memorandum. However, the bank auditors are not supposed to be given this valuation report, because the bank auditor probably would like to take it only for ascertaining the security in that case while they are auditing. So that is not supposed to be used for the bank audit purposes. However, for the resolution applicant, it may even give complete information about the assets which are part of this deal. So the second question is from Narinder Agarwal, and Narinder Agarwal says, what should be the basis of fee of a valuer? This is a very, very relevant question. Most of the valuers that would like to understand, while we quote the fee, what exactly you would like to consider? What are the factors and parameters that you would like to consider?
We have a slide to address this issue. This is a
Okay,
very
then
important issue.
that's a very, very important. So when the slide comes, that we will the answer. The other question is, which is from Venkatesh CV, and he says that would there be any action taken for a very, very high valuation done by a valuer at the time of sanction of loan and at the time of SARFAESI or IBC, in case the valuation is done which is much lower than the valuation at the time of sanction of loan? So to my understanding, it is not, because the perspective changes. One perspective at the time of taking loan was definitely based on the projections and based on the market scenario at that time. But now at this moment, when this valuation is being done under the stressed asset scenario, then the basis would be different and there would not be any action taken.
I agree that the valuations can change between two valuation dates. But I have a slight remark there that if the valuation report submitted at the time of bank sanction or other times was shabby, or where the reason for that value was not given accurately, there the creditor might bring that up with whoever is regulating that value at that point in time. Of course, currently we are not very well regulated as valuers, and what the bank can do is at the maximum bar one from the panel, or make a complaint with the income tax authorities that this person does not deserve wealth tax registration. But more than that, nothing might happen. But what I'm trying to say is that the report can definitely be relooked by the authorities if there is a difference.
I think this point is well taken, and the other point, and then I will close this question and answer session, because one point is that when we are comparing the valuation of two valuers under IBC, whether the total liquidation value has to be considered or separate assets has to be considered. My answer is that the separate assets has to be considered, land and building separately, plant and machinery separately, and even the financial and securities and financial assets separately. It has to be compared separately.
I would rather say that the comparison should be on an asset to asset basis. If there are, say, 10 plant and machineries, or maybe 100 plant and machineries, 10 land and buildings, then the duty is, of course, to have a comparison of each and every particular asset and not even look at an asset class.
So now we will continue for this webinar for another half an hour. And the next, because I have taken first 4 questions, so Rakesh Mehta ji will take the next set of questions after 30 minutes. So Rakesh ji, please take up
Yeah,
the questions whenever it comes after 30 minutes, please. Ankit, please go ahead.
right, right. So moving ahead, we have these these some NCLT NCLAT orders which are totally relevant to the evaluation exercise under IBC, and this NCLAT order, which is dated very recently, 13th March 2020, has upheld the NCLT Mumbai order in the case of Corporation Bank versus Unimark Remedies. The NCLAT in this case refused to interfere in the order of the NCLT Mumbai and upheld that judgment or did not interfere with it, only remarked that the process be completed ASAP. So this is in the case of Unimark Remedies Limited, where this is a pharmaceutical company, and this company is understood was understood to be having intangible assets related to various registrations, various licenses that the company had to deal with pharmaceutical products. And the corporation bank and some other lenders having a small percentage of 7% of the total COC went to NCLT Mumbai complaining that the valuation is not accurate and the valuation reports are not giving the accurate amount which is basically attached to the intangible assets of the company. And there the court commented that the valuers have not referred to any method of valuation, number one. Then the court said that with respect to, basically in this case, the valuation reports had remarked that the intangible assets are disputed or they are not pure because there are some warning letters issued to the company with respect to their registrations with various authorities. And there the court said that there was no critical assessment of risk faced by the warning letters, and an outright rejection of outright conclusion that the intangible assets are valued at zero because of the warning letters might not be accurate. A critical assessment of risk faced by the warning letters had to be carried out. Then, of course, the court said the valuation is not exact science and court can disregard such report unless there is a patent error. And in this case, the court said that there seems to be an error in the valuation of intangible assets, and the court ordered the RP to appoint a fresh valuer. Now, this judgment of NCLT slash NCLAT is a departure from previous judgments. So, various previous judgments of the Supreme Court, High Court have rather given valuers an authenticity that they are experts and their valuation opinion is the last opinion. But I think as we move forward, we will perhaps see more and more such judgments where the valuation report is challenged for not being adequately reasoned, not being adequately supported by the facts, supported by conclusions, supported by analysis, and therefore we will see the reports being analyzed with more detail. Further, with IVS stepping in, and IVS has of course been here for a long time, any departure or any non-compliance with respect to disclosure with IVS will lead to further analysis of the valuation reports. I will move on to the next two cases. So these two cases are also related to valuation, very recent judgments. The first one I mentioned before that there are various such judgments. I just picked out one where the NCLT has mentioned and taken support or taken cognizance of the valuation of the assets and put the company into liquidation from the CRP process, or in some cases also put the company into liquidation and into I would say into liquidation, and in some cases also into dissolution, where even liquidation did not make sense because there were no assets. In this case of Indian Bank versus J. Karthika, the NCLT Chennai passed an order, and they simply said that the Indian Bank had challenged the background of this case is that the Indian Bank had challenged the valuation on the ground that the valuation is very different from the valuation which was done by the bank panel valuer. And the bank, the COC member had not given any reasons for noticing any defect in the valuation report per se. they only mentioned that it is defective because there is a very, very sharp difference from the original valuation process. And so we therefore need to say that we therefore need to understand that also it is important in this judgment that the NCLT looked into the valuation report that was submitted by the registered valuer during the IBC process and found that the valuation is reasoned adequately. So this case involved valuation of a land or a building where the land was only leased by the Tamil Nadu government and was not really transferred, and the transfer rights were not available with the company. So the valuer simply valued, the registered valuer in IBC valued it perhaps correctly by saying that this will only fetch some money from the Tamil Nadu government and it cannot be transferred freely in the market. Whereas the bank panel valuer perhaps had taken the value based on the market comparison without taking into account this factor. So I will just excuse me for a second, please. 627. Okay, so I will resume now. So there was some technical issue that wanted my attention. So during this presentation, we will talk about the IVS wherever the IVS is applicable in the whole process of IBC valuation. And it is important that we talk about IVS because the company's registered valuer and valuation rules require that we comply with internationally accepted valuation standards or standards adopted by the RVO. And many RVOs have adopted international valuation standards. And even if we talk about some RVOs like ICAI RVO, which have adopted the ICAI standards, the ICAI standards are very close or almost similar to international valuation standards. I will briefly talk about the registered value framework because some of our participants will be interested in understanding the current situation or the current numbers in registered value framework, and perhaps some of us will also be interested in how the draft valuer bill is perhaps going to change that framework and look at valuation also as an opportunity rather than only as service providers. So for opportunity for themselves, it might be a good idea to be registered valuers for insolvency professionals and other professionals who are part of our seminar today. So of course, we have these dates as to when we started. So 31st January 2019 is again a very important date for registered valuers. Updated numbers are about 3073 as yesterday. There are about 22 registered valuer entities, out of which 10 entities are for all the three asset classes. And of course, we have a 2,500 page report comprising, which also includes the draft valuer bill from IBBI, from Dr. Sahu, led by him, and basically creating a new institute called National Institute of Valuers, which will be set up to take care of all valuation requirements. And the new framework continues the RVO mechanisms, but with a new name by the name of VPOs, Valuation Professional Organizations. Valuers who are registered under the existing system will be deemed to be valuers registered under the new bill. So it is a very, very important thing that everyone will like to understand, that if somebody becomes a valuer under IBBI, he continues to be the valuer under the new regime without any interference, without any requirement to reappear for the exam, and even to the fact that the date of registration will be deemed to be the registration that one had in the existing system. And then there is a system of an associate valuer, fellow valuer. One becomes a fellow after 5 years of recognition under IBBI or NIV. So it pays basically to be registered valuers earlier than other fellow valuers. So all of you can think about it. The new system also makes a departure by differentiating valuer institutes from VPOs and allows VPOs and valuer institutes to function in tandem, as one entity can be VPO as well as valuer institute, and certain entities can be only institutes and only VPOs. So it enables universities to basically take the place of valuer institute and teach valuation. The new system is also very interesting that it basically forecasts that valuers will become full-time valuation professionals. So it forecasts a 4-year valuation full-time, 4-year full-time program for non-graduates and 2-year program for graduates. And then it allows all existing valuers to appear for, who have an experience of 5 years, to appear for an exam and become valuers under the new regime without any qualification requirement. That is available to them for 2 years. Then they also allows the existing system of certain professionals having certain experience to join in as valuers under the new regime after giving the examination, as the current system works. That is also carried forward in the new regime. The beauty is that this new regime is expected, or is proposed, I would say, to continue into, of course, IBC Companies Act, SEBI, it will continue, but it will also extend to LLP Act, SAFESI Act, PMLA, Banking Regulation Act, which will cover all the, which will perhaps cover all the valuation requirements from banks for their sanction of secured loans. Securities Contracts Act, then IRDA, Pension Fund Regulatory Development Authority, Wealth Tax, Income Tax, Benami Law, FEMA. So it will basically all valuation, regulated valuations and non-regulated valuations in India will be covered under this new law. I will now move on to the valuation requirements under IBC. And these 5 principal requirements are there for IBC. Valuation requirements as on date since 31st January 2019. Only registered valuers registered under Companies Act are supposed to take up these valuations. We start with CIRP, we then talk about liquidation, then we talk about a fast track CIRP, although this has not been very popular. Then we talk about voluntary liquidation, and then we talk about individual bankruptcy. So these are the 5 spheres where insolvency professionals are, or liquidators, or I would say bankruptcy trustees are required to appoint valuers, or may appoint valuers. When we talk about CIRP process, we talk about Regulation 27 of the CIRP regulations, and we talk about how the resolution professional has to appoint the valuer within 7 days of his appointment, but not later than 47th day from the CIRP commencement date. And there are 2 valuers required to be appointed, and of course there is a qualification criteria that there should not be any conflict of interest, and that is why these A to D options are available. I will not go into details because I think this is something that we are all aware of already. I will go through this valuer appointment and valuation process, and basically I will seek Ms. Rakesh ji's thought process and Rakesh ji's experience at AAA, where what kind of information is normally received from resolution professionals whenever we get a RFQ from them, and maybe we can have the experience of other other panelists in our panel today as to how they feel that what all information is required and why is it required to give a fair quotation for the valuation assignment.
Yeah, thank you, Ankit ji. In fact, when we ask for details, very few details are available, and only maybe the financial for the last balance sheet which has been filed with the ROC or the MCA, that is normally available, and that is all what we get in the first stage. In fact, it is upon us that we need to contact the IP and have a discussion with him on what all we need to know from him in the first instance. For example, we have to do the markets, we have to do the survey from various websites, various economic websites, and find out the details ourselves. And based on that, we are normally trying to do justice to our valuation quote. Now, coming to the scope of work and quotation, practically for all CIRP and liquidation, there's a one-line statement that yes, this is under the quotation has to be given for fair value and market value, and
fair value and liquidation value,
or realizable value as may be, with respect, and should be compliant with IVS or any RVO work. If we talk of the issue of appointment letter again, it is so brief that sometimes we have to discuss and then make corrections, or even give us a counter letter that yes, the payment terms are to be incorporated, and the time durations which are not realistic. Normally what the IP writes is that you have to submit the report in 20 days. So all these things have to be clarified at that stage
So
during
what
the issue
I
of a
will like
point
to
letter.
add that
Yeah.
whenever we give a scope of work and a quotation, that scope of work and quotation, we attempt to make everything that is required to be part of the scope of work,
Right.
part of that scope of work. And when the appointment letter is issued in reply to our scope of work, it basically becomes an engagement document set. And that is how we tend to complete this requirement of the IVS 101, which requires a particular scope of work to be talked about and all that to be addressed. Coming back to
So
the yeah,
Ankit, can I
yes,
just
Anil.
step in here? So I think a couple of important issues I think that need to be borne in mind when an IP is requesting a valuer for a quote, is that there is very scanty information available in the beginning, and some more information is normally required, and it should be available and interactive enough, and facilitate the valuer to be able to give a proper quote. It's also important to note that sometimes an IRP would appoint you, and then that would either get sort of
Maybe an RP is appointed who is
ratified by the
different.
RP, ratified, but sometimes it can even happen that the IRP's appointment gets renegotiated later by the RP. So I think such issues also arise, and usually the appointment letter, as Rakesh rightly said, is very it lacks payment terms. Sometimes it's not clear whether it's upon submission of a draft letter, a draft report, or is it submission on the final report? Is there any so I think those issues need to be clarified, and the timing of submission of the report is quite unilateral in many ways. So I think many RPs believe that work can be completed within 14 days. Never mind the entire set of documents that need to be gone through, because in some cases you can have a whole lot of data coming in which is required by the valuer to be able to give a good report, a quality report, and that needs some time. So I think the time is pretty wishful by most of the IPs who award work. I know there is a time limitation with them, and they have to have the valuation report available, but I think they should bear in mind that they should also facilitate information that needs to be required after awarding the work to be able for the for the valuer to be able to complete the work in time.
So I will like to come back to the point, because this question of how we in the organization assess the work based on the limited information that we have from the RFQ, and what questions do we generally ask to come at a conclusion of how much we should code for that assignment and how much effort and time we will have to spend on that assignment. So so these are the primary questions that we ask. One, we talk about the details of the company's financials, and the company's financials, in my opinion, reveal a lot about the kind of assets, the size of the company, the size of the assets, because even if you have, say, audited financials which are 2 years old, they will give you a broad idea of what the size of the company is. And it's rarely seen that a 5,000 crore company becomes a 5 crore company overnight, because the balance sheet 2 years back, 1 year back did have 5,000 crores in it. It will have at least maybe 4,500, maybe 4,000, maybe even lesser. But the point is that the complication for those assets, the complication in valuing those assets will be clearly visible from those financial statements. Then we talk about the locations that the assets are present. Why I say locations is because the insolvency IBC mandates for the valuer to conduct the physical verification of assets. Now this requirement is very, very important, because this requirement is also a check on all the other activities or all the other processes, whether it is the CD, whether it is the IP, because the valuer is supposed to value only those assets that are physically available, at least the tangible assets. And of course, when you talk about intangible assets, they have to be verified through other means where the legal ownership of the company needs to be verified. But physical verification of inventory and fixed assets is mandated by IBC, And there, that is why the locations are important. If I have to travel to 10 locations across India, I will have a different quote. Also, in several requirements, RFQs, the expectation from the valuer is to quote in and give a quote which is comprising of out-of-pocket expenses or traveling expenses to those areas. Some people say that that is not right. Some people say that is right. My perception is that if a valuer from Delhi is willing to do a valuation in Kolkata, then perhaps the COC and the RP, they are justified in thinking that we should compare the costs based on the our landing price or our total price to the valuation exercise, and we should not give the lack of benefit to a local valuer who is available very close to the valuation, the assets to be valued. So there I think that is important. Then we always see that whether we always assess beforehand whether the company has the prospect of being valued as a going concern, because a going concern valuation will involve a lot of effort from the valuation team. It will include making assumptions, forecasting cash flows, doing a very in-depth industry analysis to forecast those cash flows. And that is why it is important to understand that. Then I think all my plant and machinery partners will agree that without a list of plant and machinery, and especially without, so when you talk about financial statements, you only see a plant and machinery head and you see a total value against those assets. In some circumstances, even the schedule of fixed assets is not available. So we are only relying on the total value of fixed assets without having the breakup of those assets between various asset classes. So what is important there is the list of plant and machinery, so that we understand that, what is the complexity of the plant and machinery. In various cases, that is not clearly visible or clearly understandable from the financial statements. Then, of course, we need to understand the conflict of interest. So when we have the financial statements, we have other documents, we understand who are the promoters of the company, we understand the MCA database on, so we need to understand if we ever had a conflict of interest with that CD that we are proposing to value. And of course, then we continue based on this, we quote, and then based on that, there is a scope of work, there is a quotation that has to be in compliance with IBS 101. The appointment letter might be very small in some cases, might be lengthy, but the idea is that together with the scope of work, it should form an engagement letter defining the primary objectives of the valuation exercise. The conflict of interest disclosure, of course, is the next step, that after the appointment letter is taken by the registered valuer, this disclosure is a must, where the RVE or the RV individual, they sign the disclosure and send it to the RP. The RP also uses this disclosure and then files it with the IPE with respect to the appointment of the valuer. And if any of you don't know, then the IPE websites have publicly disclosed data on who is the valuer appointed in various resolution cases, in various resolution matters, and what is the fee assigned to that. So that is public data for everyone. Then, of course, you have a request for information that the valuer sends across to the RP. This is where I think I can put in some comment that rarely do I see the resolution professionals actively sending information that they feel might be relevant and which has not been asked for by the registered valuers. And I think there needs to be a departure to this practice in the industry, that the resolution professionals should actively send everything and anything which might affect the valuation exercise. Site visit inspections normally follow after some information or some basic information is received, so that the documents and the financial statements and other information can be collated with the actual verification, site verification. And of course, then we can proceed with the draft valuation report, which is then considered by the RP, which is preceded by the final valuation report.
I want to add something here. I think,
yeah.
When we get a balance sheet and we're looking to give a quote, I think we also see the investment portfolio of the company. Sometimes we've seen cases where the company has a lot of subsidiaries or associate companies, and those companies have a lot of value, and the revenues of the core company may be very small. So, I think when you're quoting, when we are quoting, we are also looking at the investment book and seeing very clearly, are there any subsidiary companies which we may need to value, which may have attached certain value to this.
I can completely agree with Nitin, and thank you for pointing it out. That was missed in pointing out as a pointer in this RFQ, issues in RFQ. So we always seek this information because we consider that the value which is residing in the financial statements with respect to the subsidiary or the associate companies of a company of a CD is required to be valued wherever the subsidiaries are solvent companies. So I will just take it forward. So there can be, of course, loans to the subsidiary given by the holding company. There can be investments in the subsidiary in the form of equity, capital, or other instruments. And that is where it is important to understand the scope of work in those subsidiaries, as Nitin pointed out.
So one point, Ankit, that I want to point out about the the qualification that I think the IP needs to do in terms of who to select as a valuer is that he should be clear about he should ask for the approaches that the valuer would take in order to arrive at the value. So I think he should take some basic idea from the valuer as to how he intends to approach this valuation after he's provided them with sufficient number. Or he can ask them in the quotation itself. I mean, provide me with the quote and provide me with a quote along with a formal approach or a methodology that you need to use. So in that, I think it will be clear as to the kind of effort that will be involved from the valuer side.
Yeah, Anilji, I totally agree with you. And I would rather say that some insolvency professionals, very, very recently, in fact, participated, interacted with us and asked us to present the valuation methodology and the valuation approach, the valuation techniques that we will be following. And that kind of due diligence on part of the IP or the RP would really help the process, because that kind of questioning or technical questioning with the valuers will allow the resolution professional to select the valuer who can do justice to the report.
Yeah.
Ankitji, we recently had a case wherein we got a balance sheet for 2018 and we prepared a quote for the same. And the issue carried on for about a month and a half, and subsequently we got the revised balance sheet as on the CIRP date, and we had to revise our quote also.
Yeah, so that's okay, because I think if the RP is constantly following up for the financial statement, the recent financial statements, and the time is available with the RP, that 47-day time is still available, I think the RP can, of course, revise the financial statements and look for a requote. This is especially important where the financial statements are not reflecting the correct valuation, the correct assets. So in case, you get a balance sheet which has a long list of assets which are not available physically, then it makes sense to kind of work on the revised balance sheet. So
regarding the voice, there is a feedback again regarding the voice. I think we all have to be a little closer to our mics.
I will try and make that even better. I will just plug this in closer to my. Perfect. So I hope it is better now, and I will take it forward now to the valuer appointment and the valuation. So basically the appointment of valuers, we have multiple options. The RPs, they can appoint 6 valuers if they have multiple asset classes to appoint valuers for. They can also appoint the 6th appointment. They can also issue 6 appointment letters against joint proposals. When I say joint proposals, I talk about the three valuers for different asset classes coming together and putting in a joint proposal that they might be willing to work as a team on a specific valuation requirement. And then, of course, the appointment letters can be issued to registered valuer entities or registered valuers who are having the license to practice multiple asset classes. So I would like to point out here that the RP needs to be careful that, in fact, not the RP, maybe the valuer also needs to be careful that whenever valuers are acting independently on a valuation requirement, they have to take into account and they have to consider and maybe merge the thought process with through the RP or basically otherwise with respect to the basis of value, the premise of value, assumptions, industry knowledge. They have to, of course, think about whether they are willing to or proposing to do a going concern valuation. Then who will be doing the going concern valuation between them? They will also perhaps be interested in identifying operating and non-operating assets jointly, or maybe in tandem with each other, maybe in agreement with each other, and testing the sum of parts valuation with the going concern valuation also becomes important in some cases. So these are requirements that I would say impact the valuation like anything in many cases. And it is a requirement perhaps from the valuers to consider these independent individual valuers who are doing one asset class to consider the effect of these things in their valuation report. I will move on to Rule 8.2. Rule 8.2 of companies registered valuers and valuation rules puts the responsibility of the valuation report on the registered valuer who has been appointed by the resolution professional. So basically the idea is that the registered valuer may obtain inputs for his valuation report or get a separate valuation for an asset class conducted from another registered valuer, but he shall fully disclose, and he may fully disclose the details of the inputs. But the idea is that irrespective of the nature of inputs or valuation by the other registered valuer, he shall remain to be the person responsible for the valuation report. Compliance.
Ankit, can we have some questions now?
Yeah, please.
Yeah.
So in fact, we should actually thank our participants that there is a continuous flow of questions. And I only took 4 questions, and today now we have 54 questions stock. And in the meantime, on the chat box, I'm trying to reply various questions. Maybe that I've replied about 20 of them so far. But I'm requesting all the participants to put your questions on Q&A segment, so that will be taken up. And I think now you can take up, and anyone who actually has the answer can reply.
Yeah, Anilji, the first question will be, I think, for you. Yes. Is the valuer supposed to consult RP by way of draft report and discuss with him?
No, certainly the draft report practice is good practice, because this would verify the facts of the case and so that there is no error. So the purpose of the draft report should not be to influence the opinion of the valuer, but it should only be to verify the facts of the asset. And also, in case there are certain scenario or there are certain factors which the valuer might have skipped, and to remind that parameters to the valuer. Nothing more than this.
So I will. I think I can add something to it. I also feel that the draft also allows the valuer to verify and confirm with the RP about information that they have received and information that they have not received. So in many cases, the office of the RP is interacting with the office of the resolution, the registered valuer. And in those circumstances, there can be actually a human error, where certain information passed on by the RP's office to the RB's office is not included in the report. And with the draft report, even that gets checked. And of course, the 2 reports, when the 2 drafts come in, it allows the RP to look into the facts, look into the 2 reports, and point out any information, any fact which is missed out by one of the registered valuers.
So Ankit, while this during the question answer session, can you just stop sharing your screen so that we all
I will do that. I will do
only for this question answer session.
Yeah.
Next question we have is from Mr. Vikas Agarwal. He wants to ask whether a caveat should be given in the valuation report under IBC pertaining to the validity period of the report. If yes, then what should be the time period beyond which the valuation report stands invalid?
In case of valuations that have been initiated for the CRP process, during the CRP process, those valuation reports are required on the CRP date. So the valuation date is not of any dispute. The valuation that the registered valuer gives is on the CRP date.
Yeah.
And whether it is valid for 6 months, 1 year is totally dependent on the market factors that influence that company. So in case there is a change in the assets physically available at the CD because of some damage, then that will of course change the value. But the idea is that the valuation report is supposed to be on the CRP date only. There is no change in that thought process. So the validity question will depend on the market factors, economic factors, condition of the company, going concern of the company, and how that is changing over time.
No, absolutely right answer Ankit has given, because the valuation report is as on a date. And there is no validity for any valuation report.
Then there are a couple of questions regarding the valuation and the liquidation value, fair value, etc. So I would request the participants to hold their horses. We will be coming to that in the subsequent slide. And one question, of course, yes, is there any criteria as to liquidation value can be how much less than market value?
I think we will cover that when we talk
about
that
also.
Value.
Yeah. Then there's an anonymous attendee. He is trying to pose a question. I am the RP for a CD having debt of over 7,000 crore. Both the valuers were encouraged by the support firm to reduce the valuation. What could be the objective?
No, this is something that we should not answer about the objective of any person. Why should we? We don't understand the objective. The only thing is that the positive feeling that I am getting about is that the only positive feeling about anyone who is an experienced person under IBC is to bring the value as closer to the market value as it can be. See, otherwise, as I was sharing with you, like in case the valuation is very high as compared to the perceived market value, then the CIRP and the liquidation process would be totally disturbed. And no person who is supporting the CIRP or liquidation process would like that the entire process actually gets disturbed because of the valuation only. So there cannot be any other objective. That's what I believe.
Okay, we have Ms. Savita Agarwal and a very pertinent question in today's scenario. Post COVID-19, as a RP, do we need to get fresh valuation done to consider the impact of COVID-19?
I don't think the fresh valuation is required. And while the COC would be comparing the or considering the resolution plans, the COC can also consider that in mind, that this is a post-COVID scenario and there may be a little dearth of investors. And in the case of Supreme Court, in the case of Maharashtra seamless case, it has already been decided that the resolution plan can be accepted even if it is less than the liquidation value. And it is a Supreme Court judgment, so there is no question that the valuation should be done again. The COC only can factor in the COVID scenario and can accept the resolution plan.
Also, I would say that there is no legal mechanism under CRP regulations to do the valuation again. Also, it is very important to see that the valuation date has to remain a CRP date. So you can't factor in COVID when you say that the CRP date was maybe 1 year before or 6 months before today's date. There is no practical way of factoring it because of the legal requirement of IBC. The only practical possibility of revaluing the assets is in liquidation rules. In liquidation regulations, where the RP is allowed to take a decision to get the valuation done again if he feels that there is a significant, for whatever reasons he deems fit. So that's a very open case where the revaluation can be done. But there also the revaluation perhaps can be done if the valuation was not was done under CIRP earlier. If you've already done valuation under liquidation rules, the rules still don't allow you to do a valuation again and again.
One more pertinent question which Mr. Pranav Ambaselkar is asking, and in fact, I also wanted to ask Anilji, why do RPs disregard payment to valuers? Valuation fees are minuscule as compared to other insolvency costs, but RPs avoid paying valuers. All valuation fees are received after a delay of at least 2 to 3 months.
So what I believe is that most of the RPs are also under stress because of the CIRP cost funds are not available. The committee of creditors are not really very comfortable in giving a free flow of funds. They are taking their own time in getting sanction from their head offices and from their sanctioning authorities. So this is the reason the RPs are not getting any benefit by just holding on to the payment of valuers. Only there is one objective, that they would like to have the report duly signed, and after the draft report is considered, and only then they would like to give. So before the RP gets the funds from the CIRP or from the Committee of Creditors, I don't think the RP would be able to release the payment. However, whatever the case may be, all the valuers must assure that their appointment has been ratified and their fee has been approved by the Committee of Creditors. In case it has been done, then the payment of the valuer is assured as a part of the CIRP cost. And even if the assets of the company is equivalent to the total CIRP cost, the valuers will get their money. So in case the valuers are feeling that the RPs are delaying the payment, I think when you quote the fee, you should factor in that concept.
The one point that I want to make here is that particularly in the liquidation appointments, the valuer can, the valuer sometimes sort of ask by the liquidator to wait till the liquidation sale happens, and then, so I think those kind of clauses one should be a little wary of, because if somehow the liquidation sale doesn't materialize, then I think the valuer can may not sort of recover the cost that he's incurred in the valuation assignment. So I think those issues, I think when liquidation assignments are taken up, I think there one needs to be more careful. And at the same time, in CIRP, one has to be careful that it's not linked to a delayed COC approval. So I think the draft report is given, but the COC has to approve, and the approval happens much later in the CIRP.
So even during the liquidation process also, the regulations has been made under CIRP and as well as under the liquidation process for the contribution of liquidation cost by the banks and financial institutions. In the afternoon session, I would be deliberating on this concept, how the liquidation cost would be funded during liquidation process. So this is an important issue because most of the valuers are suffering. But of course, this is the scenario, not only valuers, even the RPs are also suffering.
Right. So I'll take the last question.
Yeah. So one thing that I will like to put in here, I will like to understand the IP thought process with respect to the process of getting the valuer fee approved from the COC. What is the exact requirement? Maybe Mr. Goel can share that. And what is the process in the COC? Because many valuers don't understand the process of the COC in sanctioning the fee for the valuer.
So the first and foremost, in case we see this liquidation process, and in case the liquidator decides to get the valuation again, the liquidator has to appoint the valuers within 7 days.
Right.
In the case of CIRP, the liquidator has to appoint the valuer within 47 days. So within these 2 days, within these 2 dates, in case the liquidator or the CIRP is not appointing the valuers, then there are orders by IBBI, and there has been serious actions taken against the RP and the liquidator why the valuation, why the valuers were not appointed. Even on the other hand, there is another order by the IBBI which says that it is the duty of the RP to follow up with the valuers and to provide them all the documents for getting the valuation reports. In case the valuation reports are delayed, RP is responsible. That kind of order is also there. So with these kind of orders in hand, what I understand is that the valuers has to be appointed by the RP after a process is followed. Process of asking the fee quotes, after providing the information about the assets to be valued, and getting the fee quote from multiple valuers, and then choosing and the basis for the choosing. All this has to be presented before the COC for ratification of the appointment and the fee. In fact, the appointment of a valuer is not required to be ratified. It is only the fee which is required to be ratified by the COC. However, my experience of participating in more than 500 COC meetings personally, I have seen that the COC is presently looking at even the selection of the valuers rather than only ratifying the fee. Because if they can always say that we don't like this fee and we would like the fee to be reduced. substantially. So with that particular pretext, I would advise most of the RPs to keep all this fee code prepared, and in the very first meeting they should actually present all these fee codes and let the COC decide about the fee as well as the valuer. There is no harm to you. But in case you would appoint the valuers without even asking COC, this would actually create some negativity in the CIRP process as per my experience.
Also, perhaps I can add that wherever the COC does not approve the budget or the fee for the valuers in that first meeting that you're talking about, there what we see is that the the RP still appoint the valuer, but they put a condition in the appointment letter that this is subject to the approval of fee by the COC, and then they seek that approval in subsequent meetings. So that is how the compliance is managed by them.
Okay, I'll take one last question before we proceed, because questions are many. And we have also been discussing this aspect in our company, whether a company closed for past 3 years can be valued as going concern.
Certainly, as far as the going concern is concerned, like anything which can be restarted, anything which can be revived.
We have a slide and on a going concern, and we can discuss
we
that
have
at
actually
length.
prepared a case study. We're just talking about
We
this
will talk.
particular case.
I think
we will talk
it later.
about this in detail.
So I will only take one question, and which is repeatedly coming through this chat box, and that question is coming like, how can the securities and financial asset valuer can value the inventory, because he would not be able to understand the condition of the component or condition of the item. So my answer is that the inventory has to be valued collectively by a valuer of plant and machinery and the valuer of securities and financial assets. As far as the condition usability of the component, that has to be assessed by the engineer, and as far as the costing of the component is concerned or item is concerned, that has to be verified from the books of account by the valuer for securities and financial assets, and both collectively will give the valuation, and the valuation for stocks should actually be signed by both of them.
So rather, I would add here that the inventory can be of a nature which is totally different from either plant and machinery or SFA. It can be, land and building inventories. In that case, I normally club that as a land and building asset rather than talking it.
Of course. It depends on the nature of the inventory.
So similarly, I will give you an example. Let's say there is a jewelry. So jewelry is not an asset class right now, and jewelry can be it can be something which is not any asset class. So maybe if it is a very important part of the whole process and there is lack of technical expertise in the valuation in that asset class, then one can always seek external advice. With respect to generic inventory, like if I talk about maybe some kind of goods that are marketable, then you normally evaluate based on the market value of those assets, understanding the condition. If the inventory is made for a specific use and that use is no longer relevant, then you value it at scrap. So this is the kind of thought process that goes into valuation of inventory. Whether a P&M asset class does it or a SFA asset class does it, I think is totally based on the comfort of the registered valuer in doing this valuation. And traditionally what has been happening is that chartered accountants have been valuing inventory throughout the country. And that is why there is an understanding that the SFA valuers can do the inventory valuation as well. And also one of the premises in that belief is that it is part of the SFA, because when you talk about working capital, it becomes part of that whole asset class or whole asset bunch. It is not really part of the plant and machinery, which is lying separately. But there are always questions that if you talk about plant and machinery spares, say in one of the valuations that we did for a thermal power plant, there were spares that were accounted for as inventory in the financial statements. And those spares were not understood because those spares were totally alien to the SFA valuer. So there, as you said, that the technical expertise of the plant and machinery valuer should come in valuing those spares.
I think now you can start sharing your screen and take the next section.
Share my screen and take it forward. So I think the screen is back up again. And
yes,
what I want to do now is I want to briefly talk about the scope of work and what are the requirements in IVS 101 to complete the scope of work. I'm not going to repeat whatever is already in the IBC. I will just mention it again. So IVS 101 lists down these all these things as the requirement to be compliant with. But if I talk about IBC, the identity of the valuer is very clearly available almost in all circumstances. Conflict of interest is already required to be disclosed in IBC. Requirement of material assistance from others is also almost covered in IBC itself, in the act itself. So I don't need to follow on IVS 101 to complete that compliance. Then I have to talk about the identity of the client. Again, the identity of the CD is mentioned in all appointment letters. Other intended users are also coming in from the act only, because the IBC itself talks about who can the report be shared with. Assets being valued, again, not a problem. I don't think there is any dispute in IBC valuations on this part. Valuation currency will almost always be the INR currency, because we're dealing in that. Purpose of the evaluation is again calculation of fair value and liquidation value in case of CIRP, realizable value in case of liquidation. Basis of value, again fair value, liquidation value, the basis is also well defined. Valuation date is again defined to be the CRP date. The nature and extent of the valuer's work and any limitations thereon is something that in my belief is not part of that IBC rules and regulations. So we need to be careful about putting this into our scope of work whenever the valuers give a quotation. Then the nature and sources of information on which the valuer relies is again something that needs to be completed till the time the valuation assignment is completed. That has to be shared. Significant assumptions or specific assumptions need to be specified in the scope of work. Type of report, again, not very relevant to IBC evaluations. Restriction on use, distribution and publication of the report is again not very relevant because IBC law governs it. Valuer will assess the appropriateness of all significant inputs. So again, this is one undertaking that is required under the scope of work to be in compliance with IVS 101. And of course, as per IVS 101, any changes in the scope of work must be communicated to the client. Then these are some IBBI orders which were earlier being mentioned. These are very important orders. We have to learn from past mistakes of maybe fellow professionals, fellow valuers, I would say not basically mistakes of, I shouldn't put it in that way. I think it is something that is evolving day by day because it's all new. And therefore, we need to understand that wherever IBBI has taken record of certain questions, certain violations, certain contraventions, we can learn from that. So if I talk about, I have listed this in the order of the most recent orders. So one of the recent orders dated 27th April 2020, the RP or COC, the question of IBBI was that did the RP or COC interfere with the evaluation exercise when they were seeking questions or seeking the valuers to explain their valuation reports. And in this kind of a scenario, basically one of the things that came out was that the valuers did change their valuation report, did change the report values, but it was understood by IBBI that there was nothing on record that mentioned that there was a change because of some kind of coercion from the RP or the COC. Here, I would like to say that, in my opinion, the resolution, the registered valuer should change a value in the final report as compared to the draft report in 2-3 circumstances. One, if there is any additional information that was missed out and that was provided after the draft valuation was shared. Secondly, if there was an assumption that was not right or that had to be reconsidered, then I think there can be change in value. And thirdly, in case perhaps there was certain information that that kind of led to a different basis or a different thought process. So in case, say, the draft valuation report issued by the registered valuer totally assumes that there is no chance of a going concern, and the RP subsequently gives the information talking about the fact that there is a chance of going concern valuation. So and the registered valuer says accepts that thought process of the COC or the RP. So there, there can be a revision in the valuation report. So some examples from my end, maybe we can discuss that further. Coming to the second thing, second order here, despite the fact that the two valuation reports obtained under CIRP process were close to each other, they were not having a huge difference in the valuation, the COC went ahead and appointed a third valuer. So there, the IBBI clearly said that the RP can only appoint a third valuer as per the regulations, and if he's of the opinion that there is a significant difference, and the appointment of a third valuer is not allowed. Further, the IBBI very clearly said that the RP cannot delegate or assign his duties and responsibilities as provided under the code to any third party. So the IBBI took this as a contravention, that the RP delegated the authority completely to COC and did not interfere when the COC was appointing or decided to appoint a third valuer. Then it also talked about the demarcations of responsibilities between COC and IP. So we need to be, all IPs need to be careful about this duty. Then 27th February order, again a very, very important order, where the valuer obtained approval of COC for a higher amount for the valuer fee, but incurred lesser. So this was held to be not to be a contravention. In fact, it was understood and the IBBI decided that this was a good part, that the valuer, the IP was able to save on the costs of the valuer as compared to the COC approval. Then the IBBI order dated 26 February 20, it talked about how the RP directed the valuers to value properties not owned by the CD. So again, very, very important consideration. A lot of us already know that we need to be careful that we need not value the properties that are not owned by the CD and that are owned by the personal guarantors. Then we talk about failure to appoint valuers. So 17 December 2019 order. Then we talk about 28 January 2019 order. Then we talk about 12th November order, where the valuers were not appointed. So there the IBBI always took this as a contravention, and basically this should not be allowed by RPs. The appointment has to be done in time. Then this was a very interesting order dated 15th October 2018, early days of insolvency, where the delay in receipt of valuation report was understood to be maybe a contravention, not necessarily a contravention, those are early days, but the IBBI said that there is a duty of the RP to follow up with the valuer to get the valuation report in time. It can't be endless time that the valuation report is stuck and it is not being proceeded with the valuer by the registered valuer. Again, 23rd August 2018, the order said that the appointment of the same valuer in 4 different cases without any record of due diligence for selecting the same valuers is not right, and therefore it needs to be reconsidered. Any opinion on this from my fellow?
So I think to your earlier point, I think in CIRP, I think if the assumption of the valuer will should normally be a going concern. Because the entire attempt is that of resolution. So I think the point would be that the assumption would be basically a going concern. Unless the COC is met and this, RP and COC have sort of recommended, and COC has recommended the liquidation of the company. So I think in that sense, if there is a basic disagreement on the premise of value in terms of between the valuer and the RP, so I think that needs to be that I think needs to be discussed between them very clearly.
So therefore, I think it's
a draft report is in that sense a good thought process. To
even a discussion between the RP and the registered valuer as to the possibility of getting information and possibility of the unit actually going in as a going concern is important.
Yes, so but normally the valuer would exercise his own judgment even here. I mean, I think he needs to collect enough information from the sources, from the IP sources, and also from the market search and all that, to be able to get to this answer himself. I think he should not rely on the IP completely, but he has to make his own judgment in this regard.
Understood. So I think I can move on to the next topic. So we're now looking at Regulation 35 of CIRP regulations, and we talk about how the requirement is to compute fair value and liquidation value. How the international valuation standards are required to be adhered to, how physical verification is required for the inventory and the fixed assets. A lot of this has already been discussed. And of course, the idea is that at what point in time does the valuation report be shared with the other participants is again important. So in this judgment that I was talking about, where we talked about the recent judgment of 27th April 2020, recent order of the IBBI, it was also, it actually benefited the RP when it was understood as a fact that the draft valuation report was not shared with the COC. Only the final report was shared with the COC. So that also helped the RP in saying that the valuation report was not influenced by the COC. So basically the report needs to be shared with the basically the COC only after the receipt of resolution plan. We now go to fair value and liquidation value. Why are we going to these definitions from the scratches? Because these premises of these valuation principles are important. These valuation principles are important to understand the assumptions that are required to be taken by the registered valuer in conducting the valuation process. And the resolution professional should also be aware of the importance of these values so that they can take corrective action if there is any mistake in the assumption. The fair value means, so this is the definition of fair value, and it talks about estimated realizable value. It talks about only the assets and does not talk about the liabilities of the corporate debtor. Then it talks about the insolvency commencement date being the valuation date. Then it talks about the willing buyer, willing seller, arm's length transaction. Talks about proper marketing. Talks about knowledgeability and acted with knowledgeability, prudently and without compulsion. I will compare this definition with the definition of market value in IVS 104. Now, this is an important comparison because market value under IVS 104 is very, very well defined. And we need to compare these two premises of value to understand the expectation from the registered valuer when he's computing this fair value. And therefore this comparison is important. So if you see this comparison, you will see that proper marketing is at both places. Knowledgeability, knowledgeably, prudently, without compulsion is available. Arm's length, willing buyer, willing seller is also common. What is different is only these three aspects, where IBC definition talks about an estimated realizable value versus IVS talks about an estimated amount. Now this, I think, in my opinion, is not different. This is only a difference in the terminology used. It will not result into any different interpretation of the definition. Then IBC talks about the valuation as on CRP date, and market value under IVS talks about the valuation date. And that is obvious because market value under IVS is a generic definition. It will not point out to a specific date, because the date can vary under IVS. But for IBC, CRP date is important because that is an important date when the asset goes into a CRP process. The third part, the third difference is that IBC fair value defines assets of, mentions assets of the corporate debtor, whereas market value in IVS talks about asset or liability. Here we are very, very clear that the IBC process does not require the valuer to compute the liabilities of the CD, because the liabilities of the CD are being valued by the and through the process of admitting the accurate claims. And in case of a market value in IVS, there might be certain assets which require the liability to be valued because the market value might be computed for a share or for some interest of the shareholder. So therefore, this is the only difference, only relevant difference in fair value versus market value. I will now go to the various concepts of market value in IVS, so that the same concepts can be brought into when we are imagining the value of, imagining the fair value of the assets under IBC. And this is important because when you're imagining this value, you have to make assumptions, you have to presume certain things, you have to make certain disclosures about it. So therefore, all these concepts are important when we are computing the fair value under IBC. So price is supposed to be expressed in terms of money. The most probable price reasonably obtainable in the market is required to be computed. The best price reasonably obtainable by the seller and advantageous price reasonably obtainable by the buyer. Now this is again important because we're talking about the best possible price available for those assets. You're not talking about any inferior price when you talk about fair value. Then you talk about how the estimate specifically excludes an estimated price inflated or deflated by special items. So basically you're saying that you will not take into account any special items. You will not take into account any special value which is available to a specific person. Of course, if there is a specific value available to the industry from the condition of an asset, that's a specific thing, but not for a specific owner or a purchaser. Then you talk about value of assets or liabilities as an estimated amount rather than a predetermined amount. When you talk about when you say on a specific date, you talk about that the value should reflect the market state and circumstances on the date of the evaluation date. So giving an example, if you talk about a power producer asset or a power producer company, the condition of the market today or on the CRP date is what is relevant. If on that date the power is not sellable in the market because of the low demand, then that is the market state and circumstance that you have to take into account when you're computing this value. Between a willing buyer, again, this is a very, very important part of the definition of fair value, where you say that the buyer is somebody who is motivated but not compelled to buy. Similarly, that the buyer is the one who purchases in accordance with realities of the current market and with current market expectations. And the assumed buyer would not pay a higher price than the market requires. So the idea is that in case you're in a market computing fair value where the market is down on the CRP date for that particular industry as a whole, then you have to take that factor in the market in the fair value also. That is the idea behind this definition or this conceptual framework. Willing seller again is important because you talk about a seller who is motivated to sell the asset at a market term for the best price attainable. And you say that the factual circumstances of the actual owner are not part of this consideration. So you're saying that if the CD is under insolvency and the CD is basically going through a tough time, you are not talking about the actual circumstance in which the assets are getting sold. When you talk about a fair value, you're talking about a circumstance where the actual owner is would have been selling the asset in the market as if he was a healthy company. When you say arm's length price, you talk about between parties who have no particular relationship. I think that's very, very clear. Then you talk about proper marketing. Now, this is again very important, that fair value assumes proper marketing. Fair value assumes that the asset has to be valued based on the assumption that it will be properly marketed. Now, what is proper marketing? It means that the assets has been exposed to the market in the most appropriate manner to effect its disposal at the best price reasonably obtainable. So this will include two parts. One, it would include the fact that the marketing has to be done for the adequate time. That is, if some asset in the ordinary course of this economy or Indian economy takes say 6 months to sell, then that is what you will assume is available for the sale of this asset which is under insolvency. Similarly, in case you feel that the normal idea or the ideal appropriate manner to sell the asset will be to spend certain amount on the marketing of that asset, then you will take into account the fact that yes, you have done that marketing. It will not say that you have any restrictions or your hands tied that you are not able to do that. Then there must have been sufficient time to allow the assets to be brought to the attention of an adequate number of market participants. So that is the criterion that we have to follow. And of course, it is deemed to be that most appropriate to obtain the best price in the market to which the seller has access. So in case, coming back to that example, so in case a power company has no market in India today, then that will also affect its fair value, because that is not a special circumstance. That is not a special circumstance for that company. That is the general behavior of the market as a whole. Then when we talk about acted prudently, knowledgeably, we are saying that the willing seller are both the willing buyer and seller are reasonably informed about the nature and characteristic of the asset, its actual and potential uses, and the state of the market as on the valuation date. So therefore, it assumes that everyone is aware of everything that is happening. You're not talking about certain things that are hidden. Without compulsion, of course, is that you're motivated to undertake the transaction, but neither forced or unduly coerced. Going forward, we talk about the concept of market value presumes a price negotiated in the open and competitive market, and it will most probably be local or international market, as the market would be available for an asset in normal circumstances. And the market would consist of the numerous buyers and sellers, or could be the one characterized by a limited number of market participants. So if the analysis of the valuer and the RP is that this asset has a limited market in normal circumstances, even if it would have not been a part of an insolvency process, then you will talk about that market. So if it is limited inherently, then you will limit it even for the computation of fair value. If it is not limited, you will not limit it. The asset notionally being exchanged is normally exchanged. So basically the idea is that it is a normally exchanged asset in the market. Now, highest and best use is very, very important, because when you talk about market value, when you talk about fair value under under CIRP, you understand that it is the highest and best use at what you will be doing, and there is no compromise on the Habu principle or Habu premise. That is, of course, Habu is restricted to physically possible, legally permissible, and financially feasible. And then you talk about the highest and best use may be for the continuation of the existing use or an alternative use. So for an example, say there is a land and building which is located in the center of a city, and it is an industrial land. Now, the highest and best use of that land might be continuation of the industrial use of that land if the policy of the state government does not allow the conversion of that industrial land to a residential plot, or more of a development for a residential use, or there is no demand for such an alternative use. But if that is permissible, there might be possibility to convert that land into that alternative use and then monetize it with a higher value. This is, of course, then we talk about market value, and it is determined by the use that the market participant would have in mind. So you have to assume that the use of the asset will be based on the market perception. So say today you have a one floor house or one floor bungalow in say Delhi, in a posh colony like Defense Colony or other colony, and you say that what is the value of that house today. Nobody will go to that house and value it based on the rental value that that house can fetch today. The valuation mechanism will be based on highest and best use, where it will be presumed that the buyer will demolish that existing house, construct a multi-story flats, maybe 4 or 5 flats, 4 or 5 floors on that building, on that land, and sell those independently to get the best value. So that is an example of a highest and best use not being the existing use. Then we talk about liquidation value. So I talked about the fair value here. Now I will go into the liquidation value. Why I'm coming to the liquidation rules now is that when you compute the fair value and liquidation value under CIRP, the resolution professional, the COC, the valuer need to understand that if the company goes into liquidation, then the same value will be used for the purpose of liquidation also. And that is important. And because that is the fact and that is the premise in which you have to value the assets, you have to understand that the liquidation value is important not only for the CRP purpose, but also for the liquidation purpose. So whenever we are appointing valuers as resolution professionals, we also need to consider that the same value, the same liquidation values, independent liquidation values or other values will be used for the liquidation process. The liquidator shall consider the average of the estimate. So if the valuation has already been done, then you will compute the average of those original values. Alternatively, if you don't want to rely, so if the liquidator is of the opinion that fresh valuation is required, he can go for a fresh valuation. This part is important, that the that he can appoint the 2 registered valuers to determine the realizable value of the assets or businesses under clauses A to F of Regulation 32. Now, this is very, very important. Why? Because liquidation value as a premise under as a valuation basis under IVS restricts it to a piecemeal basis. Now, this is the definition of the liquidation value in IVS, and this is the definition of liquidation value under CIRP rules. Now, under CIRP rules, the liquidation value is defined to be the estimated realizable value of the assets had the corporate debtor be liquidated on the insolvency commencement date. But IBC does not restrict the liquidation to happen on a piecemeal basis. IBC under Regulation 32 talks about these 6 possible ways of 6 possible manner in which the assets of the company under liquidation can be sold. So what my interpretation is that even in CIRP process, when you talk about the liquidation value, you are talking about the possible liquidation value under these circumstances, and not only on a piecemeal basis. So not only you will compute the liquidation, you're required to compute the liquidation value under the highest and best use amongst these 6 options, there might be a requirement for understanding a multiple approach. So in some cases, the resolution professionals who appointed us as valuers asked us to value the assets based on multiple presumptions. That maybe the assets can be sold on a standalone basis. Maybe they can also be, the corporate debtor itself can also be sold as a going concern. So we have given, say, 2 liquidation values in the same valuation assignment. Now this future outlook on what is possible with respect to the CD in hand is very, very important for the resolution professional to consider. And here I think I can ask Mr. Goel to step in and maybe share his point of view, anything that he can add on to whatever I'm saying.
I think he's
okay. So I will.
So can I step in here, Anil?
Yes, yes,
okay,
yes,
for a
yes.
second. So I think so the COC may form an opinion during the CIRP phase that that the liquidation may be carried out and use and advise the IP that the liquidation may be carried out in the following manner. That is, the business, it can be the asset on a standalone basis, or it can it even advise on corporate debtor as a going concern. It can advise on any one of these bases. So I think that is one stipulation which has to be borne in mind when you come into liquidation. So I think that advice has to be carried through in liquidation. So that is one point. The other is that this basically just increases the complexity of the liquidation valuation far more intricately as compared to the CIRP, because the assumption in CIRP will be basically going concern, whereas here it can change, and the liquidator can ask you to value it on a standalone basis or on a slump sale basis. So if it's a slump sale basis, then it's more or less the going concern basis. So I think it can be, in that sense, it can.
So when we say that fair value or market value under IVS needs to be computed as a going concern, there I have a different point of view, and I think that will depend on the assets in hand. It will not be compulsorily a going concern valuation. There might be a scenario where the company has no prospect of acting or being a going concern because of the industry is loss making, industry is not working. And there might be possibility that you totally give away or you totally ignore going concern for computing the fair value also. Of course, I want to say that it will be highest and best use because the assets are located at a particular place and you feel that yes, at their actual use is the highest and best use. That is how we will value them. But the assets are allocated and you want an alternative way, and you can explore an alternative highest and best use. That is what we will think about. So say there is a CD who has a land and building, who has a plant and machinery, and that land and building, plant and machinery is not feasible to be used for the industry that they were in. Then we have to look at the alternative uses of those land and building, even if those uses are not associated with the industry that CD is operating in.
I agree, but what I'm saying is that there is a dichotomy here in the sense that the liquidator, there is a regulation which says the liquidator has to try and sell it as a going concern if he feels, if he believes, if he forms.
So of course, there has to be a bias towards going concern in case that is feasible. I'm
saying that the valuer may have a very different perspective. The valuer may have a perspective that this needs to be sold on a standalone basis, and it can never be sold as a going concern. So I think this is basically just adds to the complexity of the liquidation valuation, and the scope and the the quote, that fee that you sort of charge for a liquidation assignment has to bear this in mind, because otherwise it can lead to a lot of
this
work creep, which you
this,
cannot.
so this needs to be part of the discussion at the time of the appointment of the valuer during the CRP process. That
Yes.
when the valuer is computing the liquidation value, then
Yes.
what premise or what basis is he going to compute the
Yes.
liquidation value?
And you remember, Ankit, you and me asked this question from Mr. Sahu at one of the conferences, and literally,
yes,
I mean,
that was in
there
June.
was
That was
silence from
June
the
in
other side.
that was June on the valuer bill,
Yes.
and I remember Dr. Sahu commenting that
Yes.
he cannot expect the RP to know that what will fetch
But
the best value.
the CEO is supposed to form an opinion, you know, can form an opinion about one of these.
My thought process
So
is
what
that
I
I will
just
not.
want to intervene.
I will not say that the
I think-
COC is the decision maker. My thought process is that all the participants are decision makers, and they have to come at the best possible value with discussion. The RP, the registered value, the COC, they're all collectively trying, because under the whole code, they're trying to explore the best value for the assets.
It goes beyond that.
I think
In fact, a
Nitin want to
liquidator-
say something,
Yeah,
and
Nitin
after that, I will also add about this
So I
regulation
wanted to
39B and C.
Yes. Correct. So I wanted to just bring in a point here that, I agree with Ankit here that, Habu needs to be followed. Highest value, higher asset value we need to look at. I've seen some cases where the assets cannot be sold as on a standalone basis. So in liquidation phase, where typically we try to do sum of parts and we're trying to sell the assets on a standalone basis, there, that principle may not hold good. We may sell assets on a collective basis.
True.
Just because we want to preserve the value and we want to get the highest value for those assets. So I think that even the concept of going concern, my understanding of the going concern is that the IBC has a certain definition of going concern where essential services are provided and the CD is a going concern. But the business may not be still running. And, just because the CD is a going concern does not mean that the business will be sold at a going concern value. So as a valuer, we need to be cognizant of this fact and appropriately value it.
Also, I will like to add that the reverse is also possible. So maybe the CD is not a going concern as on the CRP date or as on the valuation date, but the thought process is that with the rationalization of the loans or with the rationalization of the debt, the CD might become a going concern in future, based on the assets available, based on the contracts available, based on the other assets or contracts available with the CD. And therefore, in some cases that we have valued, we have also assumed going concern, forecasted the future incomes coming into the CD based on maybe a time when the CD was functioning, or based on the market functions which are perceived for the future.
So I will refer to regulation 39B and C. I think it's 39B of the CIRP regulations, yes, which says that it is the obligation of COC to decide, even if a resolution plan is approved and before the resolution plan is submitted to adjudicating authority, COC also has to take a decision that in case the resolution plan is not approved and the company is supposed to go to liquidation, whether that company would be kept as a going concern or not.
Absolutely.
And then if yes, like there are two scenarios. One is that if the resolution plan is approved and the other is the resolution for the liquidating the company is approved. In both these scenarios, it is the obligation of the COC to decide whether the company would be kept as a going concern or any of the business of the company can be kept as a going concern. And if yes, then what are the assets and liabilities which would be grouped together for the purpose of keeping that as a going concern, and also directing the liquidator to keep it as a going concern and explore the possibilities of selling it as a going concern.
Yeah.
So based on this, and also based on the rationale that the COC would probably have more understanding about the asset and the company and the value and the product and the technology adopted, rather than the valuer who is just appointed. So the valuer cannot take a decision whether this company can generate EBITDA, whether this company can create some profitable model. The valuer will only understand while after visiting. Otherwise, the valuer will not understand. So primarily we are deciding a question that who will direct the valuer. Now, in case Yes, yes,
My
Mr.
point, Anilji, is this, that this is surely a dichotomy, because the valuer is supposed to have an independent opinion about the premise of value. Now, if he is governed by what the COC has said about it being sold as a going concern, or following assets being grouped together, then actually he loses his independence to a certain extent. So I think there is a dichotomous situation in the act which is there in the regulations, and that's primarily because the assumption is that even a liquidated a company under liquidation can be sold as a going concern. So it stems from there. Basically, that's why there is a dichotomous situation here. That's the only complexity.
Even in my opinion, my thought process is that even if under Regulation 39 of the CRP regulations, the COC says that you maintain this as a going concern, those functions are primarily there to allow the COC to direct the RP to keep the assets as a going concern. Now, keeping the assets as a going concern and valuation of assets, understanding that it will be a going concern, are a little different. In my opinion, the highest and best use and the possibility of the sale of the CD as a going concern under Regulation 32 can have an independent view of the valuer also. And of course, the RP can also direct and say that, no, we are interested in valuing this as a going concern. I also say that there is no possibility of valuing a company as a going concern without the information coming in, relevant information coming in from the RP. That is also something that the valuer is relying on the RP for.
No, in case we read the Regulation 35 of the liquidation process regulations, it is very clear that I think the Regulation 35 says, this slide it shows Regulation 35 of the CIRP and the Regulation 35 of the liquidator. In case we read this last line, it says, appoint 2 registered valuers to determine the realizable value of the assets or businesses under clauses A to F of the Regulation 32 of the corporate debtor. Now, the regulation itself says that the RP or the liquidator will appoint. So he will appoint for valuation for under clauses A to F. To my understanding, the COC and the RP are the best persons to decide, and they can even ask for multiple valuations from the valuer. They can ask for even the A and B and C and D and E and F. So the valuer can give all their opinions in case the COC and the RP is confused. But yes, to my understanding, valuer cannot decide whether it has to be given only one valuation or and that too as a going concern.
Yeah, certainly not. The only thing is it adds to the complexity of the valuation exercise if he has to do it under all of these options. So 32A to F, for instance, has a multiple this thing. So if there is an 8,000 element FAR, I have 8,000 items in an FAR, right? Which has actually happened in many of my cases. So to be able to give the liquidation value of each one of those items independently on a standalone basis is going to be a pretty nightmarish situation for the valuer. So I think that is another point that needs to be borne in mind. So I think the whole point, why we are discussing this on the panel is that it should be made out. I mean, the valuer should be aware of what he's taking on when he's taking on a liquidation assignment,
or even a CRP assignment, where
or even a CIRP
assignment, where the liquidation value is required to be computed.
In CIRP, a valuer is more safe in the sense that there is an assumption of a going concern, at least, So I think, the CIRP, the IP cannot sell the assets on a standalone basis, except 10%.
So in some of our assignments,
I think Nitin can also take questions now, because I think there are 103 questions that are.
I will just share some experiences where we have worked on this Regulation 32 and we have given values accordingly. So in case of a running power plant, we gave in the valuation report the fact that we are valuing this only as the corporate debtor as a going concern, because there the PPAs were relevant, the purchase agreements for coal or the coal arrangement agreements were important, and none of the other values were feasible or would have been chosen by any person at all. Similarly, in one of the cases where there was a factory which was manufacturing alumina, which was shut for a long time, we assume that factory will never be sold on a piecemeal basis, because on a piecemeal basis, on a scrap value, it will fetch nothing at all for their individual assets. it will destroy the value, and therefore we created a going concern thought process for that shut factory, and incorporate all the costs. So basically what I'm trying to say is that in many cases the valuer will be able to choose 1, 2, or maybe 3 of the 6 of these premises, and then do the valuation accordingly. I think it's time for questions. We are sitting at 1:20, and we can ask some
I
answer
think
some questions.
Nitin can see some of the question, or Mr. Sharma or Rakesh, anyone can see the question, because there are many questions that I could notice.
I'll see questions. So
Okay.
I'm just looking, I'm answering, seeking some questions. So one of the gentlemen has asked this question. This is Devinder Singh. In case if final selection of resolution applicant is voted and the matter is pending in NCLT for approval, then can the resolution professional can keep doing work like possessions and registrations? Is it a going concern in that case?
See, this is a real estate question, and when we understand the real estate company, and the company's role is to complete the construction, hand over the possessions, and also transfer the title to the allottees. So this is what is called the operations of the company, and it is the duty of the RP to keep the operations of the company as a going concern basis. And even if the resolution plan is approved, the RP is supposed to keep the operations of the company as a going concern, unless this is impacting the resolution applicant. So in case the RP is doing something in a different manner, and in the resolution plan it is provided in a different manner, then there will be a conflict of interest. Like the resolution plan says this, and the RP is dealing with those assets or liabilities differently. So except for that, RP is entitled to continue the operations, whatever is the operations of the company. For a real estate company, the construction, possession, and even title transfer is the operations of the company, unless it is impacting the RA.
Okay, thank you. I'm going to ask another question. This is a question from Amit Bindalish. Does a registered valuer need to value minority shareholding of the corporate debtor in a private limited company? If yes, how is getting information is very challenging, as RP does not have access to the said private limited company's management information. So probably I can answer this.
No, I think the question is slightly, it has to be modified. Whether it is during CIRP, the question is it during CIRP or otherwise for a M&A transaction?
I think it is for CIRP.
I think he's talking of, this is CIRP. He's talking of
I think
IBC.
he's talking about the subsidiary companies or associate companies.
Yeah, so he's saying that if there is a associate company where they are holding maybe 20% shareholding, the corporate debtor is holding 20% or 25%. So, you know, in these scenarios, you don't have access to the company management. My answer to this is yes, the RB is required to value, because, you know, sometimes we see there is a lot of value coming in. Today, we are valuing an asset which has multiple associate and subsidiary companies. And today, the maximum value in that asset is coming from an associate company where we just hold 19% share. So it is very important, as a registered valuer, you need to seek information and you need to create evidence that you are seeking information. Please give me this information. I want to create evidence. If the management or the RP is not giving you information, at least you have done your part. You've created that evidence. Anil, do you want to add on that?
No, I definitely agree with you, because this is a very big challenge for all the valuers, especially the valuers of SFA. Because the information is not coming. The information about receivables, advances, claims, refunds is not really coming, and especially the investments. So we are dealing, as you know, you are also handling the CIRP, and with all our partners, like 42 partners are handling many companies where where even the subsidiary companies are 10, 12, 15 companies are subsidiary companies. So whenever we are trying to do the valuation, either we are not getting the financial statements or we are not getting the business model of the company, because all those subsidiary companies, we hardly have any control. However, the recent NCLAT judgment has actually held it, that is in the case of Vinod Kothari. he took over the management of a subsidiary company, appointed the nominee directors, and NCLT held it is an appropriate action by RP. So in case you feel that the information is not coming, then the RP should try to change the management. RP should try to take the control of the management, and then of course you will see that the information is coming.
Right, right. Okay, another question is, by Anil Mehta. Can the value given for the CARP be not used for liquidation value? Does a new valuer need to be appointed when liquidation happens? If yes, does a valuer need to be different from those appointed during the CARP process?
Regulation 35, sub-regulation 2 is very clear that the liquidator has to decide whether the fresh valuation is required or not. And if the liquidator decides for the fresh valuation, although it is not mentioned in the regulation, but my experience and my advice would be to go for a fresh valuation, means fresh valuer also.
Okay, there's a question from Payal Chatterjee, which is asking, can the valuations be challenged by the corporate debtor?
There are certain cases where the valuations are being challenged by the corporate debtor. And the only thing is the timing is very, very important. What is the timing of challenge? In case the challenging the valuation is done after the resolution plan is approved, then I think it may not be appropriate. However, we actually have a case where there is a case of I think Arcel versus Corporation Bank, where the NCLT in fact decided to appoint, directed the RP to appoint a third valuer, and that was a case of Arcel versus Corporation Bank. And the reason was that even the valuer failed to give even the basis of the valuation. So there are other judgments also where the NCLT has held that the valuation can be different.
So exactly. So the timing of the challenge is very important one. And of course, when the CD challenges a valuation, and if the challenge is based on the valuation techniques, the actual valuation report, and it is able to sustain some ground in the NCLT, it might cause a delay in the whole process. But I read 2-3 judgments where NCLT has ignored that challenge, because maybe NCLT also understands that there might be a malified intention on part of the promoters of the CD to challenge the whole process due to valuation.
Right. So there's another question, Amit Sharma, he's asking a question on the RB fees. The registered valuer is expected to quote his fees on the basis of balance sheets available and other preliminary data only. This data may not be reliable and can be revised further in due course of time. It may happen that the original promoters may have manipulated this data, so he's asking that, he's saying that the balance sheets may not be reliable. So you're putting a fees on something, the premise may not be, the premise may not be correct.
Maybe I can answer it. So, this is, I think, prevalent in all professions, that you always try and estimate the time that you will put into a assignment. If there is any possibility of getting 100% of the information right on day one when you're expecting a quote, then of course that will be preferred. But if that is not available, then what are the options? The option is only to start the process with the limited information at hand. We have in fact experienced in one case where the RP found out that there were additional assets available with the company after he appointed us as a valuer. And there he gave us a supplementary appointment letter which had additional fee in it. Because that original scope of work, that those original assets which were belonging to the company were not factored in. Those locations where the assets were lying were not factored in. So I think this was a good premise which we can share here, that in case there is a substantial change in the assets available with the company and the scope of work has substantially increased, the RV can always request the RP to seek COC approval for additional fee for those additional assets.
In another
I
case,
would like to also add here, one part is that whenever you sign an engagement letter, in the engagement letter, the asset that you are going to value must be specified. And in case later on and the new assets are found, then you can always go back to RP, and the RP can go back to COC for approval of the additional fee based on that engagement letter.
Right. I think it's already 1:32. So probably we'll take this last question. were NCLT cases why they ask two valuers for an asset class. If these two jointly give one value with a difference of 10%, which is not matching the market value for the resolution, what will I do?
No, I always make sure, although practically it is not becoming possible, that in case two valuers are appointed, and the RP should make sure that both are independently visiting the site and both are not meeting, because the RP should not disclose the name to each other. Although the RPs are nowadays telling me that we actually have to upload that information for appointment of professional. But so you see, I also have a little gap in my understanding, because I feel that in case you appoint a related party, then only you are supposed to report. In case you are not appointing a related party, maybe that you report later, and by after some time, because you have to just declare the fee which is paid to a particular valuer. So you should do that later. But while the valuation is being done, nobody should know who is the other valuer. Otherwise, that actually becomes a kind of a non-professional thing, that one person goes and the other person just goes for record, and the job is done by one person. The other person is just making a
I
copy of
also
it.
would say that as registered valuers, it is more of a point of integrity from our own thought process. You know,
Yeah.
we have come across situations in our organization where the RP has shared the other number with us, the other valuer, so that we can kind of have values which are similar. We have circumstances where we have got calls from the other valuer to seek whether our values are matching with their report. So it is also about integrity of your own opinion, and how you will, as a registered valuer, like to have your strong opinion about the valuation that you have arrived at. And I think that's important to this whole process. The idea is not to merge the two values. The idea is to have two individual opinions. And in case those individual opinions are different, then appointing a third valuer is always the solution. The problem comes in where there is a delay in the whole process and there is no time to appoint a third valuer. And that is what I think should be avoided. That is the most valid reason, or most prevalent reason why there is a pressure on merging the two values. The pressure is because of the time being short and the resolution plan already being submitted.
So what is the program now? Because see, we are already at we see the original the webinar was planned for 2 hours. We
but I think
already have completed 2 hours.
We had a lot to cover.
We have a lot to cover, and there are something like 11 questions, and we have only been able to take about 20-25 out of these. I think we can just complete 1 or 2 slides, and we should finish by 13:45. And then we'll start. Then we will also announce for the part 2, which will be on the next Sunday on the same time.
So I am going back to the report. So my slides, and I will simply finish. I will just finish the liquidation value concept. So I've already discussed the fair value under IBC. I've already talked about how liquidation value under IVS is only talking about the piecemeal basis and not talking about the other possible manners of sale. I will now also like to talk about the two premises in which IVS talks about a liquidation value. One premise is orderly liquidation. Orderly liquidation suggests that there is reasonable period of time to find a purchaser, with the seller being compelled to sell on a as is where is basis. Whereas in case of a forced sale assumes that the proper marketing period is not possible and buyers may not be able to undertake adequate due diligence. Now, whether the liquidation value is computed on the premise of orderly liquidation or in the premise of forced sale will depend on the case and depend on the actual case as to what is the normal period required for the sale of that asset. Is there any pressure on timelines which will not allow the liquidator to fetch the right price from the market? And that is where there has to be a decision between the premise of orderly liquidation or forced sale when we talk about the premise for calculation of liquidation value. And we also talk about then the nature of the pressure on the seller, the reasons why proper marketing cannot be undertaken. We also talk about the consequences for the seller of failing to sell. So one idea is that if the liquidation starts and the liquidator is not able to sell the asset. The consequence is simply delayed. The consequence can be delayed receipt of money on for the COC members, for the creditors, for the stakeholders. The consequence can be failure. Consequence can be decrease in the value of the assets because of erosion, because of depreciation on the assets. Those can be the consequences. And the idea is that the discounting on forced sale as compared to an orderly liquidation will depend on what is this loss that might be caused on the asset because of this, because of any possible delay in the sale. So maybe if you talk about, say, an example where the liquidation process is delayed by a year, we need to talk about what is the cause, what is the loss that is happening. Maybe the loss that is happening is that the creditors will lose the interest on the money that they're realizing for that 1 year time. Maybe the result is that the market for that asset further declines. Maybe the result is that the technology of that CD, that the technology that they're using becomes obsolete. So these are some examples which will affect how much percentage of discount will you give to compute the liquidation value over the fair value. And that is what I think were questions, that what is the percentage that you should reduce from the fair value. I would say you can reduce 10%, you can reduce 25%, you can reduce 35%, you can reduce 50%, but you have to justify why you are reducing that much. You have to talk about the cost of money in case the value is realized after a year. You have to talk about the negativity or the possible litigation that might be faced by a person who is buying these assets in liquidation. You might be talking about some certain regularizations that are required in case of liquidation process. So we have to put in all those factors and then compute the liquidation value. These are again some of the premises of these are basically the conditions that are required for a forced sale. So short time is important here. Market conditions prevailing as on that date is important. So all these are factors that will influence whether we want to talk about a forced sale or an orderly liquidation. Then there are entity specific factors we have to consider. So in case of say an additional value or reduction in value derived from the creation of a portfolio of similar assets, unique synergies between the assets and other assets owned by the entity, legal rights or restrictions, tax benefits, ability to exploit an asset that is unique to that entity. So these are the factors that you will have to consider in computing the liquidation value, which are not available to any other entity, which are unique to this entity. And it will be on a case-to-case basis. There is no possibility of a synergy. And I will now, I think this can be the last slide for the day. And we can briefly talk about the strategy of valuation. I think we have discussed a lot about it already, where we have to consider the assets and their condition. We have to ask whether there is a possibility of a going concern for that entity. We have to ask about the location of that entity. Where is it located? So in case there is an industrial plot located right in the middle of Delhi, say there is a factory running in Okhla. Today, that factory may not be having that the alternative, the highest and best use for that factory might be office, converting it into an office space and using it for an office as a commercial office. So, or renting it out as a warehouse. That might be a alternative use that is better. So then you talk about sale in tandem, where you talk about selling the building which is owned by the company in tandem with the land that might be owned by one of the corporate debtors. So you might have to talk about that in your valuation report, because in various cases there are premises where you only have the building is owned by the CD, the land is owned by the promoters. So how do you value? Do you want to say that the building has to be brought down and then only it will have a value? Maybe the building has a value as a standing structure if it is sold along with the land. So you have to factor in that. Then you have to talk about the industry. You have to talk about the peers and competitors, see what they are doing. Is there any scope for that industry? You have to see the land, and you have to see whether the land is in an active market or does it or not. Does it have an alternative use or not? Similarly, machinery, you have to see the suppliers, traders, other users in the industry, and decide your valuation strategy as to how you will like to value the assets. So I think with that, we can then, so what we're basically doing is we will be in the next session to come. We will of course talk about the computation of enterprise value for computing fair value. We'll be sharing our experiences in some of the cases that we have done with respect to enterprise valuation. We will talk about the information in documents. We'll talk about other things that we planned on doing in this session in the next series, which will continue to this webinar.
So I think we thought while we were preparing our PPT that this session cannot be for 2 hours, and we also decided that we will not force close the session, and understanding like whatever we have worked, whatever we have researched, that should completely go to the participants. So with this objective, now we are saying that yes, the question and answer sessions were very, very important. Each and every question was very, very important. And we also believe in one thing, that one question is asked by one person and the answer goes to all the 700 people participating. So while I'm saying so, I also say one thing, that one question that we are able to answer, that means that we know the job. In case we are not able to answer that question, we'll go back, we'll work on that, and we will try to find an answer. That is also our way of learning. So with this concept that whatever we are doing, basically it is for our own selfish motive, and that is we want to learn, and this webinar is our way of learning. With this, we would convey all the thanks to the participants. They all remain connected with us. 700 of them remained connected with us during this 2 hours 15 minutes. Thanks to panelists, everyone contributed a lot, and we will again come back with the rest of the research that we have done on next Sunday at same time, 11:30. Till that time, wish you always wish you safe and completely protected from the coronavirus, and stay happy. Thank you very much.
Wish everyone good health, and we will be sharing the YouTube recording for this video with all the panelists and all the people who registered for this seminar. And we will also share the link to register for the one that is scheduled to be on the next Sunday.
Thank you. Thank you.
Thank you, everyone.
Thank you, everyone.
Thank you, everyone. Okay.
Thank you.